Well, good morning, Jagendra Rana here. Topic for our discussion today is exclusion clauses in insurance contracts. Exclusion clauses in insurance contracts. The terms of insurance contract require a strict construction without eschewing or adding the words in the contract. However, insurers are exempted from any liability where the loss is attributable to an excluded peril specified in the exclusion clause or not mentioned in the covered causes or perils or risk or loss. So the term exclusion is self-explanatory. It spells out the things not covered in a contract and require more attention than any other clauses in a contract. So the terms of the insurance contract require strict construction. Further, doctrine of contra pro forensum applies against the drafter of a document which says that ambiguity in the wordings of the document is to be resolved against the party who drafted it. And this rule applies even with greater force to adhesion contracts like insurance. In addition, the exclusion term of the insurance policy must not violate the main purpose of the contract. Else it would be either read down to give effect to the main purpose of the contract or to be held in fundamental breach of contract and will be given no effect. So like any other provision in a contract, words of exceptions or exclusions must be read in the context of contract as a whole and with due regard to the main purpose rule, which says that any amount of exclusion will not save the party of a contract if it defeats the main purpose of the contract. The exclusion clauses may be void if interpreting their ordinary and natural meaning gives an absurd result or defeats the very purpose of the insurance contract. So as far as judicial pronouncements are concerned, the cases decided by the honorable courts says that in the case of General Assurance Society Limited versus Chandumal Jain, it was held that there is no difference between a contract of insurance and any other contract except that in the contract of insurance there is a requirement of ovarian fights, that is good faith, on the part of the assured, and the contract is likely to be constituted contra pro forensum, that is against the company in case of ambiguity or doubt. So limitation to the rule of contra pro forensum are also there. In the case of Surajmal Ramnivas Mills Private Limited versus United India Insurance Company Limited, the Honorable Supreme Court held that while construing the terms of the insurance, the words used therein must be given paramount importance, and it is not open for the court to add, delete or substitute any words. Therefore, the endeavor of the court should always be to interpret the words used in the contract in the manner that will best express the intention of the parties. The main purpose of rule is that the Honorable Supreme Court of India in case of V.V. Nagarju versus Oriental Insurance Company Limited said, while deciding the issue whether the alleged breach of carrying passenger in goods vehicle more the number permitted in terms of the insurance policy is so fundamental breach so as to afford ground to the insurer to eschew liability altogether, held that the exclusion clause of the insurance policy must be read down so as to serve the main purpose of the policy on the ground that carrying of extra passengers could not be contributed to the accident. So adhesion contracts are there. Black's Law Dictionary defines that the adhesion contract means a standard form contract prepared by one party to be signed by the party in a weaker position. So usually a consumer who has little choice about a terms, also termed contract of adhesion, take it or leave it contracts. So these contracts are prepared by the insurers, having a standard format upon which a consumer is made to sign. He has very little option or choice to negotiate the terms of the contract except to sign the dotted lines. The insurers, who being the dominant party, dictates its own terms, leaving it upon the consumer either to take it or leave it. Such contracts are obviously one-sided, grossly in favor of the insurers due to the weak bargaining power of the consumer. But there is a doctrine of the blue pencil. Doctrine of blue pencil says that the opposite principle evolved by the English and American codes has been duly taken note of by this court in Bid District Central Cooperative Bank Limited versus State of Maharashtra. So the doctrine of blue pencil was evolved by the English and American courts and Halsbury laws of England. It stated that severance of illegal and void provisions. A contract will rarely be totally illegal or void, and certain parts of it may be entirely lawful in themselves. The question therefore arises whether the illegal or void parts may be separated or severed from the contract and the rest of the contract enforced without them. So blue pencil doctrine say a judicial standard for deciding whether to invalidate the whole contract or only the offending words. Under this standard, only the offending words are invalidated. If it would be possible to delete them simply by running a blue pencil through them, as opposed to changing, adding, or rearranging words. In Max Texco Marketing Private Limited versus Tata AIG General Insurance Company Limited, it was held that the appellant secured a standard fire and special peril policy from the respondents on 28/7/2012. The policy was effective from 28/7/2012 to 27 July 2013. Now, it was meant to cover a shop situated in the basement of the building. However, the exclusion clause of the contract specifies that it does not cover the basement. Now, due inspection of the shop was made, which was actually situated on the other side of the road from the office of respondent number 1. Not only this, the shop of the appellant, but another shop similarly situated was also insured. So the appellant continued to pay the premium promptly. The appellant put up further construction for which due notice was given and due inspection was also made. So the shop met with a fire accident for which the appellant raised a claim. The surveyor of insurer also made an inspection on the basis of which the appellant was instructed to refurnish it shop for the purpose of due evaluation. So while arriving at the sum payable, the surveyor did notice that the fact that the earlier inspections were made and the fact that the shop was in a basement was to the knowledge of the insurer. So the claim made was repudiated by the insurer, taking umbrage under the exclusion clause. So an exclusion clause in a contract of insurance has to be interpreted differently. Not only the onus but also the burden lies with the insurer when reliance is made on such a clause. It can never be understood to mean to be in conflict with the main purpose for which the contract is entered. Such a clause has to be understood on the prism of the main contract. For the main contract, one side would eclipse of the offending exclusions clause. So when it would otherwise be impossible to execute it, it has got to no ability to destroy its own creator, that is the main contract. When it is destructive to the main contract, right at its inception, it has to be severed. Thank you. Thank you very much.